You're listening to the Quint's podcast.
The 47th Chief Justice of India, Sharad Arvind Bobde, demits office on April 23rd. Under his tenure, India witnessed some critical moments such as the first wave of the coronavirus pandemic, followed by the migrant crisis, the ongoing farmers' protest, and now an even more infectious second wave where there seems to be a severe shortage of crucial medical supplies. But how did the Supreme Court fare in this moment of extreme crisis under his leadership? What kind of a legacy is CJI Bobde leaving behind? One marked with controversies and criticisms for sure, if not for consequential judgments. So, on the same day that CJI Bobde demits office, he heard a suo motu case regarding the COVID crisis in the country, where he indicated considering transferring the slew of cases regarding the pandemic that several high courts have been hearing. That move is something that had been widely criticized by top advocates in the country. And as he sets off to retire, let's take a look at the highlights of CJI Bobde's tenure. He was recently quoted saying, "Let justice be done, though heavens may fall." But could he dispense justice in the way that was expected of the CJI and the Supreme Court? Joining me in this podcast is my guest, Vakasha Sachdev, the Quint's legal editor. Hi, Vakasha.
Hi.
Welcome back
Hi,
to the Big Story
everyone.
podcast.
It's been a while.
You're tuned in to The Big Story, the podcast where we dissect the headline making news for you. And I'm your host, Shalburi.
So, Vakasha, let's talk about the final act first. Undoubtedly, the pandemic posed the biggest test for the Supreme Court under CJI Bobde's tenure, right? When the centre's poorly planned lockdown triggered the whole migrant crisis last year, at the same time, the Supreme Court and CJI Bobde did not really swing into action as was expected of them, with a number of petitions that were placed before the court asking it to take some amount of action at that point in time. And when it came to holding the centre accountable for the migrant crisis, the court bought the government's version of the event on face value when it said that there were no migrants on the roads, even though there were actual reports and videos and photos documenting the plight of migrant workers. And then the court even declined to pass an order saying something to the effect that, what can the Supreme Court do? It can't stop people from walking on the roads. And now, a year later, when we're in a crisis situation yet again with an acute shortage of ICU beds and oxygen, CJI Bobde is asking the centre for a national plan on the last day of his job. Is it too little, too late for his concern now?
I mean, I think this is the we look at the way the court dealt with the migrant crisis. This has been unfortunately the experience, right? As you pointed out, last year, what's interesting is that there were a couple when the crisis started. It looked like the Supreme Court might actually really step up to the plate because Bobde actually did two very important things. CJ Bobde, he actually one was he suo moto brought up the case of what about the people who are in jails, people who are in prisons at this point of time, and he's ordered the setting up these high powered committees which would look into seeing which categories of people could be released from prisons, whether on bail or on parole for those who are convicted. So that was a laudable step. He quite early on they got rid of physical hearings, but also said, okay, we will continue to have urgent hearings, and we're going to now get video conferencing in. I mean, so on at that time, it for a moment it looked like he was really taking this seriously and was going to do a good job. And one of the things about CJ Bobde is that which I think people would have told you even before his tenure started, is that he's seen as someone who's not very confrontational. Now, there is an argument we made that at a certain point, especially when you're trying to hold a government to account, now you need to do that. But you could make the argument that a less confrontational approach, a more collaborative approach, was more helpful at the time when you've got a national crisis. But the problem is that that only works when all the sides are working in good faith. The day the central government came up to the court and in response to those migrant crisis stories literally made up its own stories and said, oh, there are no migrants on the road, that was the day when a collaborative approach doesn't work anymore, right? Then you have to start asking questions. And that's where he completely failed to do that, because if the central government was absolutely correct and there was nobody on the road, then sure, then there's nothing to be done, right? If the government is saying, oh, we've already done all these actions, then sure, but there's a duty on a court to ask those questions. You don't just accept this at face value. You'll say, okay, fine, give it to us on affidavit, show us the exact steps. something to that effect has to be there, especially when you had all the reports, and as you said, there was more than enough evidence that that wasn't true, which was all in the public domain. I mean, these judges are not sitting in an ivory tower where they don't have access to the internet or to the newspapers or to TV. They can see and they know what is happening out there. There was no way he did not have access to those images, and yet to accept the government's version at face value was it. I mean, that's an abdication of your responsibility, right? That's an abdication of judicial responsibility, and this is the and this is where it just starts to get really bad, because then even afterwards it took 2 months for them to finally consider hearing something about the migrant crisis, and even then, they were again just still taking government statements at face value. The government told them something about, oh, we're not charging migrants for trains. If you remember when they had started those Shramik trains, the
Yeah.
government openly
Yeah.
said we are not charging them. Nobody's being charged for it. Whereas again, everyone knew that that was not true. So this kind of, and this was what marked his whole thing. And so then you suddenly now come 1 year later, you've not bothered in between at all to even the case which he did, like on the prisoners thing. He's not even had one follow up on that case, even though there have been severe problems with the way those orders were being implemented, and the way those high power committees were actually looking. There was a very clear thing that that instead of looking at the age of the prisoner, which is what is important, right, and comorbidities of prisoners, if you're to look at who should be sent to bail, they were looking at it as purely a matter of, okay, these people, if they have, if they've been charged with this offense, forget a convicted,
Hmm.
even people who are just accused of certain offenses, even if they were like in the highest risk category to COVID, they weren't allowing them.
Yeah, like the Bhima Koregaon
Absolutely,
case.
yeah. And the point is that that if you once you pass this order, you could have very well then looked into it and seen, is this order even being followed, and he didn't bother doing that either. So, which is why suddenly
Hmm.
coming up at this stage, when again, now for weeks, this crisis has already been escalating, right? It's not as though this just happened
Hmm.
yesterday. The crisis has been escalating for weeks. He could have 1 week, 2 weeks ago, if we, what, at least by the beginning of this week, he could have been asked, he could have said, okay, we need to have a suo motu case. But it wasn't done. And look at the way the case got set up, right? The case gets set up because Vedanta files a mentioning,
Hmm.
which was supposed to be before Justice Nariman's bench. For some reason, it's heard by
Hmm.
CJI Bobde's bench, and then from there he decides that, oh, these other that these states, that there's a problem with the way the states the high courts are dealing with this matter on a state by state basis, and on that basis he then says,
Hmm.
therefore we need the Supreme Court to hear it. Now it's all very well to say that the Supreme Court should hear it, but there have to be some actual reasons, and he says, and if you read the order which the court said yesterday, they said that the orders being passed by the High Court, and I'm going to quote here, may have the effect of
Hmm.
accelerating and prioritizing the services to a certain set of people and slowing down the availability of these resources to certain other groups, whether the groups are local, regional, or otherwise. Now, that's a pretty serious claim to make, right? You're saying that there's a difference between access, that these high court orders are destabilizing a response, right? And without any basis, right? If they had a report before it, a set of,
Hmm.
if the central government, if it had come out and said, okay, look, the High Court X said do this, but that then took away a supply from that state, and that kind of thing would make sense. But there was none of that information before them, not even in a sealed cover.
Moreover, the move to appoint Mr. Harish Salve as the amicus curiae, even though he's not even based in the country anymore. Of course, he's recused himself from that
Yeah.
role. But how are we to even look at this
I
move?
mean, the thing is, Harish Salve, there's an unfortunate truth is that this is not the first time. So, I mean, a lot of people have particularly looked at this, but Harish Salve has for many years magically somehow become a amicus curiae in a lot of cases. Now, a lot of people will try to justify it and say, oh, but yeah, I mean, he's a good lawyer. And let's be clear, he's a man who's, if you look at his record and all, he's definitely a good lawyer, right? But for somehow
Hmm.
magically for the last 20 years, or the last, okay, whatever, but if you look at the around last 15, 20 years or so, he keeps getting appointed a Micus Curie in case after case after case after case. And at least earlier you could say he was in the country, he was in the courtroom for some of those cases, even though, I mean, that's setting that aside
Hmm.
for now. The main point is he's not in the country right now. He has
Hmm.
he has openly defended the central government on a number of issues
Hmm.
publicly. And this is not as a, if he had gone there, if he had been purely engaged as a lawyer, then actually you can't
Hmm.
criticize him. But he has defended the central government in a personal capacity. This man should not then be appointed as an amicus curiae who's supposed to be impartial. Number one. Number two, the court was saying that they're going to look at vaccine strategy as well, right? It's not just oxygen deficiencies or other problems. They wanted also to look at vaccine strategy. This is the man who has represented SII
Hmm.
in cases before the Bombay High Court. So how are you have the Serum Institute? So how
Hmm.
exactly is this person been appointed to this kind of
Yeah,
role?
there's a clear conflict of interest.
It's very very clear, and I'm not going to get into, like, some people try to dig out the fact that he and Justice Bobde were classmates in school. No, like, that's not. I think that's actually quite unfair. That's not really relevant to the issue here. So if you
Hmm.
see anyone making the argument that that is a problem with his appointment, that's not really it. Because I mean, at the end of the day, just because the judge may know the lawyer, I mean, that's a bit unfortunate, but that's what it is, right? Like, you can't change those kind of things. But when
Hmm.
you've got clear, like, potential conflicts of interest on the issues, on the
Hmm.
merits of the thing, it was a decision which didn't make sense. And you could see, right, that the fact that he was literally just appointed because he was there representing Vedanta, who were
Hmm.
trying to get an order here saying, oh, we'll do it. And again, it's that request itself is also so dodgy.
Hmm.
This is Vedanta has this case with the had this case open at the Supreme Court, where they're desperately requesting that plant to be reopened. Now, this is a plant which violated pretty much every environmental norm, should never have been
Hmm.
allowed to have been set up, was somehow allowed to be set up, functioned for years without being checked. I mean, the locals in that area have had it till there. And then, if you remember, a few years ago, there was also the whole thing that when there was the whole agitations over the closure of the plant, people were shot,
Yeah.
by police forces, but protesters and all who weren't even committing any acts of violence were gunned down in the street. So, I
Hmm.
mean, for the court to be saying, yes, let's take the lawyer who's representing this party and then make them look at this issue,
Hmm.
it's it's also kind of tone deaf, right? Like, it's just not really thinking about what the issue is. And as you pointed out, the fact that he's sitting in London right now, he has no
Hmm.
idea how bad it is on the ground here right now, right? As in,
Correct.
I mean, heck, half of us don't know how bad it is on the ground
On
exactly
the
at this
ground.
moment. But at the very least, you want someone who's actually knows what's happening. Or, it starts with the fact that he didn't think about doing this till literally this time, when he could have picked this up
Last
any time
moment,
over the
right?
last, yeah, any time of the last week, the last 2 weeks, he could have started looking into this. Didn't do it. When it comes up before him appointing an amicus who, he's got close ties to the government, just again taking things which he and the solicitor general are saying at face value, you then make statements in it which have no basis in fact. You then are going against, and the best part is the inconsistency. Bobde has spent the last year constantly telling us, oh, people shouldn't be running to the high court, go to the Supreme Court, go to the high court. Why are you filing article 32 petitions? This matter can be heard by the high court, let it go there.
Hmm.
So I mean, the
We'll
lack of.
come to that point. We'll come to that point a
Mhm.
little later. But beyond the COVID crisis, if we go back to the beginning of his tenure in 2019,
Yeah.
there were some really important cases pending hearing before the Supreme Court over the Citizenship Amendment Bill, for instance, or
Uh-huh.
Article 370, or electoral bonds. And some of those pending cases that pertain to human rights violations and threats to democracy weren't heard even under the former CJI Ranjan
Yeah.
Gogoi's tenure, which itself is knee deep in controversies. But was CJI Bobde's leadership any better in this aspect?
I mean, there's a great, like, Gautam Bhatia has done a good blog post on this. He's actually talked about. He's made the argument that potentially you could argue that what the way Bobde's handled those issues is worse than Gogoi, because Gogoi, at least is, he set up sometimes benches for some of those things. He actually, there were some hearings on some of those things. I mean, we have a lot of complaints about whatever happened, but at least something happened. Out
Hmm.
here, we actually saw even less of that.
Hmm.
The CAA bench issue, for instance, like, the way that there's a record number of petitions. There were so many like, key requests where people were saying, look at the scale of protests, look at the fear which there is, and valid fear which there is, or even if you don't agree that it is, that there is fear, there is concern, at least just put a stay on this, right? Because people's lives are potentially at risk. Put a stay on it. Later you can rule and say that it's constitutionally valid and it's all fine, right? Like, you don't have to worry about it anymore.
Hmm.
But again, he just refused to do this, for without even giving any reasons for why that was the case. And this was the whole issue with all these big constitutional matters. They were cases which have to be heard. The longer you let them stay around and don't do anything, you are essentially, it's a fait accompli in favor of the government. And that is not the way a constitutional court is supposed to function. You cannot just keep letting these cases go in abeyance. And we saw like no movement on these. Now the thing
Hmm.
is, Gogoi himself got it terribly wrong. I mean, the fact that he prioritized Ayodhya over the Kashmir cases
Right.
was, I mean, there's no justification for that on a legal basis. If we look at Bobde's tenure, he, to some extent, you might try and argue that, okay, but what about the coronavirus crisis, right? Like, as in, that's going to make it difficult to conduct hearings. That's going to make it difficult to go about things. And to an extent, you can make that argument, yes. But there were a few things which showed that the court can very well conduct even complex constitutional cases, and like complex hearings without difficulty in its current process of video conferencing. We saw this with the in terms of a constitutional case with the Maratha reservation case, like detailed arguments by senior counsel, all of that was heard, and they were able to do that even during this time. You have the Tata Cyrus Mistry controversy which is going on
Yeah.
over his that also, and that there were days and days and days and days of hearings on that case. So while you can try to give them a bit of a free pass, okay, fine, maybe the first 2 months, 3 months, 4 months of the pandemic, they couldn't quite, take on
But
cases.
what perhaps will go down in history is the fact that a contempt of court case against lawyer activist Prashant Bhushan was taken up suo motu by the court as a matter of extreme emergency over
Yeah,
actually urgent cases.
yeah, I mean that's the thing, and again, it wasn't as though that was like, oh, very short case which was heard, and you had one day of brief arguments and it got over. There were again several days of arguments there. So the court
Hmm.
evidently was more than capable of doing that. So why not do it for these matters, which are seriously important for the sake of entire sections of the population, which
Hmm.
are important for the constitutional direction of the country, right? Something like the CA, and given the allegation, what are the allegations against the CA, right? That it's a violation of Article 14. It's changing the way citizenship works in the country. That's not a
Hmm.
small accusation, right? So you need to address something like that head on. And the consequences again of these things, if you don't we saw that with Kashmir, by not addressing it, Kashmir, the union territory formation went ahead because the court again just decided not to put a stay. And now even it's again, it's just making the central government's actions a fait
Hmm.
accompli. How are you going to
Hmm.
later now roll these things back? It's going to be a nightmare. The number of administrative changes which have been made now, that's so those kind of considerations just don't seem to have been there at all when it came to
Hmm.
prioritization of cases. Now,
Hmm.
electoral bonds actually is a great example, because that was a case which could have easily been heard on video conferencing, because what you didn't need to have was a lot of papers being moved up and down to
Hmm.
show the court in the middle of things, which sometimes can happen in a lot of these constitutional cases, that you're constantly moving this compendium and showing things to the judges and all that kind of stuff. So it can be a bit difficult to do that in video conferencing. Electoral
Hmm.
bonds, all the material was already there at the court. There was literally nothing which would have to be physically moved and shown to the court. And the arguments were pretty straightforward. And yet he just refused to list that
Hmm.
case. And finally, he does, at long last, decide to list it for a brief hearing, where if you read the order, it makes no sense. He again just passes an interim order, which doesn't go into the merits of the issue at all, and yet somehow makes findings which are essentially in favor of the government. Like he
Hmm.
makes up like he points out the fact that there were no impediments created by the courts to the previous few rounds of electoral bond issues, to say that therefore it should not be stopped right now, because it shows that there's it's essentially saying that there's a presumption that everything is okay. But the reason why nothing was done during those last few bouts is because the court was not listing it, including him. So it's this kind of bizarre decision making, which has no basis in fact, no basis in law, no basis in logic. That's even worse than actually passing a bad final judgment,
And
because
I
here
and I
you're
want
just.
to sorry to cut you off, and I want to come back to the point that you were referring to before. The contrast between how the petition against Malayalam journalist Siddiqui Kappan's detention was
Yeah,
handled, as opposed to how Republic TV editor-in-chief Arnab Goswami's bail plea was handled. Wasn't that a bit hypocritical for an institution of this stature? Because in Kappan's case, who was arrested and charged with UAPA while he was on his way to report on
yeah.
the Hathras gang rape case, the CJI wanted his counsel to approach the Allahabad High Court first. But for Arnab Goswami, his case was heard by a special vacation bench, even though the court was closed for the Diwali
So I
break.
mean, to be fair, so the thing is, no matter how much one may dislike Arnab Goswami or whatever, to be honest, what the court did in his case was not incorrect. I mean,
Hmm.
You can argue that the Bombay, and what was important was that he first went to the Bombay High Court and then he came to the Supreme Court. So he had gone through that. But the point is that it's not as though you can't come directly to the Supreme Court. Number one. Number two, if Bobde was so upset with Kappan's habeas corpus petition, he could have just dismissed it. The problem was that he didn't even dismiss it. Either if you're going to have a problem with these things, then you can just dismiss the case and then not bother with it. The big issue actually which we see through Bobde's tenure is a failure to exert any sort of consistency, and this has been there throughout. There have been because essentially the Supreme Court doesn't all sit together. You have different benches, so there is always a certain degree of the fact that things don't quite match up all the time. But I mean, you could argue that perhaps there's been that problem has been exacerbated during Bobde's tenure, because we've actually seen diametrically opposite cases just keep coming up over and over again. Like you point out, the Kappan case, the fact that they didn't, the same, even if there are technical differences in the case and all that, the main point which Justice Chandrachud made during the Arnab Goswami case was that liberty in a person's individual liberty is so important that even one day's wrongful incarceration is a blight. It's not acceptable. Whereas in Kappan's case and in every other habeas corpus case which went up before the Chief Justice of India, it was like, yeah, okay, cool, fine, 1 week, 2 weeks, 3 weeks, 4 weeks, who cares? We'll hear it after some time. There was none of this urgency, which is exactly how the court should be treating something like this. You see that there, you see the lack of. I mean, there are other instances as well, where you'll see this sort of thing where the court is saying that okay, we don't need to hear this right now, but like but the way they've approached other matters has been very, very different. So I'll just pick up a couple of other examples here. So I mean, just look at the way the farm laws case was dealt with, right? Now, in this, you've got a situation where, yes, you may want to mediate and you may want to try and diffuse the situation, all that is all very nice. But the court also had very clearly had simple issues of legality in front of it, which the sooner you rule on it, the better, because the sooner you rule on it, the quicker, the protests also have to enter into their own end games and figure out what they're doing, right? But instead of delving into that, you just take forever to you set up committees which are not even going to really find any solution to this. You just let this case kind of drag on. I mean, there is no logic to this. Now, I know that people will say that, yeah, but like unless and until you're going to show CJI Bobde taking inconsistent positions, it's not a problem. But then this is a key position which the Chief Justice should be handling. They should, if you are concerned that there's going to be a lack of consistency, then send the same kind of cases to the same judge, right? Send all your personal liberty cases to Justice Chandrachud, who's then going to handle all of them in an appropriate manner. Send your cases to certain kind of cases to Justice Nariman. Send others to us. The point is that that is a role which the CGI can play if it's becoming very clear, that there is no consistency. But he wasn't doing that either.
And the administrative role of a CJI is also something of utmost importance, something that's closely observed by people. The fact that as the master of roster, he decides who will be hearing what cases or what kind of appointments are made to the Supreme Court. And surprisingly, even with 5 vacancies, no appointments have been made in the Supreme Court under CJI Bobde's tenure.
Yeah, and this is not even as though like he barely he wasn't someone who had like a just 2 3 months 4 months whatever to he had 17 months. That's the longest tenure in ages that a CGI has had. And he just, and it's bizarre because there are the way the collegium, the procedure works where the collegium recommends things to the government at this point is that if the collegium makes the recommendation and then the government doesn't agree with it, the collegium reiterates that recommendation, and then that has to be followed through by the central government. Now, the loophole which the center has found is that there's no deadline, so they can delay it. The problem with CJI Bobde was that he wasn't even reiterating things. He wasn't even sending recommendations for these vacancies, for Supreme Court judges, and it makes no sense because you can see again that the court is so urgently needed to hear so many of these important matters. You know how valuable it is to have enough judges functioning in the court at this time, and you are not doing it. And it's not even as though it's like you can say that either the court was handling its workload perfectly fine, or most importantly that there was even a fair representation issue. We have one woman judge at the Supreme Court right now. One. We had three till like 2 months ago, and now suddenly we have like one. That's just it makes no sense for a court to be in this position.
So, other than the fact that the court had to transform towards digitalization and online filing under CJI Bobde, owing to the pandemic, of course, what kind of a mark is CJI Bobde leaving behind on the institution?
I mean, he's not. That's. I mean, the problem is there is no mark by any of the normal ways we kind of try to assess that in terms of judgments or in terms of maybe some sort of administrative reforms. None of that was done.
Hmm.
Like even the, I mean, the video conferencing thing is fine, but I mean that was a necessity. We don't have to pat him on the back for
Hmm.
having done that. It's not as though they
Hmm.
invented the video conferencing tech being used, right?
Hmm.
And in fact, like of all, like the Supreme Court, in fact, uses the worst of the video conferencing technologies that there is, rather
Hmm.
than WebEx and stuff, which is it's tried tested software, which is what the high courts are using. The Supreme Court
Hmm.
is using this thing called video, which they've just, I mean, I'm not going to get into more details about that, but it's like, even there they didn't even do the very best job. And so you can't, there's no question of patting them on the back for doing the bare minimum, which is what they needed to do in this situation. One of the ways in which we could have seen him do was fulfill on the promise which was made 3 years ago now almost, for cases to be live streamed.
Hmm.
He didn't do that.
Hmm.
He took no measures really to deal with pendency in the
Hmm.
court, and the fact that he didn't fill these vacancies actually makes the pendency situation worse
Hmm.
at the Supreme Court. Um, I mean, so on even so even on the non-judgment metrics where we normally look at what is, we can say that, okay, maybe like, so for
Hmm.
instance, CJ Keher, one may not be able to
Hmm.
point to a lot of judgments by him per se during his tenure, even though the right to privacy case happened during his time. Like he didn't write a judgment in it, but like at the
Hmm.
very least, you can say that
Hmm.
there was measures he took to try and deal with pendency, etc., etc., etc. There were things which he tried, no matter how much
Hmm.
you criticize him. Whereas with Justice Bobde, it's like
Hmm.
they haven't even tried, you know. And in
Hmm.
terms of the fact that, the judgments which have been passed, which are of any significance, have nothing to do with him. They're not even
Hmm.
all of them are like good or or well done judgments, but whatever it is.
Hmm. Hmm.
So yeah, I mean, you're left with zero metrics. And now this is where there's two ways to look at this. I mean, one way to look at it is to say that he's basically just failed, and that's, I think, the charitable view, is that he didn't take action, and we will not remember his tenure because there weren't actions taken. The other, the other way to look at it is that the approach he took of not picking up things, of evading case after case, of using these interim orders rather than actual things, is you can argue that, in fact, that's a deliberate strategy as well,
Hmm.
commission by omission. And there's an argument to be made that that's there, because at the end of the day, who benefits every time you do this, right? When you evade hearing important cases, when you allow the central government to just come up and say whatever they want, government authorities to just say what they want and get away with things.
Hmm.
This, I mean, by not doing anything, there is, I mean, in a sense, a decision is being made. So, the less charitable way to look at his tenure is to say that this is the tenure which has been great for the government. They've not once been held to account. They've not once been questioned. They've not once been made to, like, answer any of the uncomfortable questions. So if you're, so when you're in this position, I mean, it's a very dangerous line of reasoning to go down any further, because there's a point where one now starts straying into contempt of court. But
Yeah.
I mean, but it's not as though there aren't merits to the argument, right? Because it's not about even if we don't impute any motives or anything to the court, the results are still the same. So even though that may not have been Justice Bobde's intention,
Hmm.
the mark he's left on the court is of a court which has actually been weakened. Its authority has been weakened here, in a sense,
Hmm.
because the government has been allowed to get away with even more than it would have otherwise been, which it was already getting away with so much.
Okay, so before we end this discussion, Vakasha, Justice Ramana will be succeeding S.A. Bobde as the 48th Chief Justice of India on 24th April. Can you tell us what all can be expected from the next CJI?
So I think he's got a lot to clean up. He's has this whole backlog of huge constitutional matters,
Hmm.
left over. So, I mean, and given the long tenure which Justice Bobde had, there should have been some dent in that. There isn't. Now Ramana has a decent tenure as well. Like it's not like a very short one, so he can actually also probably get some work done. But I mean, it's going to require a lot of will to make that happen. will which we've not really seen from the Supreme Court for a long time. It's going to require a willingness to stand up to the government and ask them questions again, which we've just not been seeing for a very long time. And I mean, this is where the worry starts to come in when you see things like last year. There was the letter which the Andhra CM Jagan Reddy, he writes this letter to Chief Justice Bobde, making all sorts of allegations against Justice Ramana. Now, the thing was, if these had just gone privately and then the court has a in-house procedure and that's been followed, and they decide, there's nothing more, then that's fine. But these allegations were made public. Like, Jagan Reddy released these things to the public, and then the Supreme Court, like, very strangely for months sat on it. Like, the in-house procedure which is used to investigate it could have wrapped this whole issue up within a week. As in, by all they basically did was essentially get Justice Ramana's view, match that against the allegations, and say this was bullshit. That's essentially what it did. But it took months to do that, rather than do that within like a week, 2 weeks, even 1 month or so at max. Which is so the problem is, it's not about whether those allegations against Justice Ramana are correct or not. It's again that the court itself also, like, the way it approached how trying to deal with this, and the way CJI Bobde approached dealing with the allegations, but it puts Justice Ramana in a problematic position, right? Because you've not done enough to really set aside those those very public allegations of misconduct. So that's a cloud which Justice Ramana is going to have to deal with, and one can hope that he'll be able to deal with it well, because he's one of the reasons why it's why it's believed that that letter was sent out was because of his orders about fast tracking of uh, criminal cases against sitting MPs and MLAs, which was viewed to be one of the reasons why, because there were several of those against Jagan Reddy, so that was viewed as one of the reasons why that was done. Now, so the hope is that he'll be able to focus on those kind of things. That this cloud which was created by Reddy's allegations and things, he'll be able to avoid it. And if you see some of Justice Ramana's judgments over the last few years, the key thing is he is quite clear with getting the law correct. Even on Kashmir, the Kashmir restrictions cases and all, he's very good with being able to say that, okay, look, this was what the obligations were and this is what should have happened. The problem is that perhaps we've not really seen him find ways to make those orders enforceable, to make the court, to make the government actually follow through with what he's saying in those. And I think that's going to be his big challenge, is he going to be able to pick up these cases? Is he going to be able to see them through, to not just maybe make a point and say that, okay, look, this is wrong, or this is in principle a problem, but like actually say that, yes, the government got this wrong and therefore there are going to be consequences. I think, if we look at the past history of the court, the recent history of the court, that's unfortunately, that's probably not going to happen. But the hope will be that we'll at least move away from this paralysis which we saw during CJI Bobde's tenure, that we'll actually have some of these cases heard, that things will at least on that basis progress.
With that, we'll wrap up this episode of The Big Story here. Thanks a lot, Vakasha, for being a part of this podcast.
Absolutely. It was a pleasure as always.
And stay tuned to the Quint for more podcasts.
If you like listening to this episode, please subscribe to the Big Story playlist for episodic updates. We're live on Apple, Google Podcast, Spotify, JioSaavn, and most of the other popular podcast streaming platforms. For other podcasts, please log on to the Quint website and check out the podcast section. For any feedback, shoot an email to podcasts@thequint.com.
Thanks for listening. Log on to the Quint's website and check out our other podcasts.